So welcome to the League of Women Voters Fall Issues Forum. It's very good to see those of you who came out tonight here in the audience. Of the League of Women Voters, although I may be repeating unnecessary information, I think it's important to point out that the League advocates for the right to vote, and it also advocates for responsible voting. It doesn't advocate for any particular candidate or party, but it also offers information, as it is important not just to vote, but to make an informed one. To that end, this fall forum is held each year to inform people on important issues of the day. Finally, we offer thanks to our panelists, Justice Marla Luckert and Carol Beier, and very graciously our host for this evening, moderator host for Sarah Bagby of Watermark Books in Wichita. I have seen Sarah conduct such interviews before, and she does a magnificent job. We're very pleased to have her here. So without further ado, I could give you a long bio, and no doubt there is plenty of information about that. But I think it's sufficient to say that two of the top-rated Supreme Court justices, Justices Luckert and Beier, are here to talk. They are widely recognized inside and outside their profession, and so we're honored to have them and look forward to hearing the conversation. So, ladies.
Well, welcome, and welcome to the two justices here who are happy to be here to make sure that we all understand the nature of serving on the Supreme Court of Kansas and to help all of you be informed in order to maybe answer some questions that you may get from friends, family, any concerned citizen who wants to know what's going on. By having each of you, Carol, you could start just your personal and professional background and why you sought a job on the Supreme Court or a spot on the Supreme Court.
Great. I grew up in Kansas City, Kansas. I'm a Wyandotte County girl. City girl, I'll say. My folks were farm folks, but I was a city girl. I attended Catholic schools there, St. Peter's Grade School and Bishop Ward High School, and started college at Benedictine. Decided I wanted to be a journalism major, so I ended up at KU for undergraduate. Worked for a couple of years for the Kansas City Times, and then went back to law school at KU. And ultimately, I got a second law degree at the University of Virginia as well. I clerked for a judge early in my career, and then worked in Washington, D.C. for a couple of years. The first one on a fellowship through Georgetown Law Center. And then the second year there in D.C., I was at a large law firm. I decided to get married and come back home. And so I moved to Wichita in 1988. I think that's shortly after that is when Sarah and I became acquainted. Mm-hmm. And that's where I raised my family for a dozen years while I worked at Fulston and Siefken Law Firm, where I became a partner. And I'd been in the firm for quite a while, and I was perfectly happy. But I thought that public service was really where I wanted to head. And a position became available on the Court of Appeals in 2000. So I was appointed to the Court of Appeals by Governor Graves and spent 3.5 years on the Court of Appeals, and then moved to the Supreme Court in September of 2003. It really was about public service more than anything. I had loved the journalism business, which I considered public service, and I had missed getting that kind of charge from my work. And so I would say that that was my main motivator, probably, to put in for the Court of Appeals and then the Supreme Court.
My background is the complete geographic opposite of Justice Beier. I grew up in Goodland, so I started on the other side of the state. And that was an experience that was fabulous in terms of the small town life where we were allowed to do anything and everything we wanted to do. And so I experimented with all types of extracurricular activities and fell in love with debate. And that debate experience, I think, probably was the first thing that kind of pushed me towards the law, because I didn't know any attorneys. I knew nothing about the practice of law. And I just very naively marched towards that career thinking that I absolutely knew that was what I wanted to do. So I, with that focus, decided that I was going to go to Washburn to undergrad because it made sense to me that I would just move right on to law school there, and that's exactly what I did. And so from that point on, my residency has been in Topeka because once I graduated from law school, I stayed there and practiced law with the Goodell, Stratton, Edmonds, and Palmer law firm, which often brought me to Salina, actually, to do various legal work. They allowed me to be there without kicking me out, and even brought me into the partnership. And I was there for about 12 years, at which time there was an opening on the district court bench in Topeka, and really not something that I had considered doing would be to move to a judicial position at the district court level at that time. But many, many, many people approached me. And one of their primary things that they said is, there are no women on the state trial court bench in Topeka and really in the state. And we need women and others who reflect the diversity of our community. So will you please think about that? And I did. And as Carol mentioned, I think almost everyone that goes into the judiciary is driven by a sense of public service. And so I did seek the judicial position. Topeka, similar to what other parts of the state, are a situation where it's a nomination and a merit selection. And 3 names are sent by a local nominating commission to the governor. I was lucky enough to receive that nomination and be selected by Democratic Governor Joan Finney to be on the trial court bench. After about 8 years of being a judge there, the Supreme Court appointed me to be the chief judge of Shawnee County. And then 2 years later, in 2002, there was an opening on the Supreme Court. And the same sort of thing happened again. People came and said, we only have 1 woman on the Supreme Court. We need more women. And actually, if I had ever thought I wanted to be any kind of a judge early in my career, it probably would have been that I would be an appellate judge. And so that had some appeal to me. Again, went through the nominating commission process. And this time, Republican Governor Bill Graves appointed me to the Supreme Court, where I have served since.
Marla was the second woman.
And Carol was the third.
So we got a ways to go.
Well, okay, so that takes me to tell us about your colleagues on the court. Who are they? Where are they from? How do you complement each other? How is it a great, what's the most important thing maybe in appointing members of the court to make sure it's, got a variety of people and sensibilities?
The beauty of an appellate court is that it is diverse. It's not one judge in a courtroom making the decision on its own. It's a discourse of several judges bringing together their collective minds, a wider range of experiences. It happens that all of us are native Kansans, but beyond that, we probably don't share a lot of similarities, and we do all either graduate from Washburn or KU Law. But we, in addition to the geographic or the backgrounds that Carol and I have mentioned, Chief Justice Lawton Nuss grew up here in Salina. I'm sure many of you know him. Another of our colleagues is from El Dorado, and then Lawrence, Topeka, and the metropolitan area of Kansas, Caldwell. If you haven't heard of it, it's a little town near the Oklahoma border.
South Central. That's Lee Johnson. He calls it Oklahoma Light. So that's Lee. Eric Rosen is next senior behind me. He's the Topeka boy. And then we have Dan Biles from Overland Park, Lee Johnson from Caldwell, and the newest member of the court is Caleb Stiegel, and he's from Lawrence. So a variety of backgrounds, too. Marla, as she mentioned, came from the district bench. I came to the court from the Court of Appeals, as did Lee and Caleb. Lawton and Dan came straight from private practice, and then Eric also came from the district bench. And I think that's one of the diversities among us that makes us strong. Our cases arrive from different places, different situations, and it's always helpful to me, for example, to be able to turn to Marla and Eric and ask them about how a district judge would react in a certain situation, or what factors might be important to a person who sits in that job. So I think those kinds of diverse legal backgrounds really help us as well.
And you all went through the same process to be appointed to the court. And can you just briefly give, it's a rigorous process. You have to go through lots of vetting. Can you just sort of explain the steps to that?
Marla and I went through the same process for the Supreme Court, and I went through the same process for the Court of Appeals. The Court of Appeals process has now changed. But the way that we appoint Supreme Court justices in Kansas is known as the Missouri Plan. That's where it started many years ago. And it involves a nominating commission made up of 9 people, 4 lawyers elected from the 4 congressional districts, 1 from each, 4 non-lawyer lay people who are appointed by the governor, and then 1 lawyer who's elected statewide by all the members who've been admitted to the Bar of Kansas. Not the Bar Association, but the Bar, everyone who's been sworn into the Bar. And those individuals make up this nominating commission. They receive submissions from people who are interested in the job or nominated for the job. Those submissions are very extensive. I was visiting with someone recently who went through the process, and she was talking about collecting all of her transcripts. This was for an appointed district judge position. And she said, I got my law school transcript, and I went back and got my college transcript, and I got my high school transcript. And she said, I got my grade school transcript. And she said, all the way back to kindergarten. I said, all your 1, 2, 3, 4 and S's and U's? And she said, yes. But she said the worst was that she'd gotten a C in driver's ed during high school. And the governor asked her about it. She said, I'd gone to my teacher later and said, why did I get a C? And they said, that's what you get when you have a wreck during driver's ed. So there's not much that you get to keep secret in the process. It's very extensive. Of course, there's extensive background checks, lots of reference checks. You need to supply names of people who've been your opposing counsel. You need to supply names of judges before whom you've appeared. So if you've got skeletons, they're likely to come out of the closet during that process. So those folks interview, and then they choose their 3 top candidates, and they send those names to the governor, and the governor appoints. And then every 6 years, Kansas Supreme Court justices sit for retention. They sit in the first general election beyond a year of service, and then every 6 years thereafter. So that's our system, and that's the system by which we arrived at our jobs.
And the retention election is a different system than what you're used to in the general political race. When you were on the ballot for retention, there is no opposing candidate. It is just, will you retain Justice X in office, yes or no? And if a majority say yes, that justice, or at your local level, your judge, will continue to serve for any other term. If a majority would say no, then that nomination commission process that Justice Beier has just explained to you would start. And names would go through that vetting process, be presented to the governor, and then the governor would select those people who would replace the justices that had not been retained.
Thank you. Okay, so I'm going to go a little bit to nuts and bolts of your daily and how you, how do cases get to the Supreme Court? Do you choose them? I think and what are the 3 levels of Kansas courts? And then what are the paths to those courts for cases? Appeals or?
Marla, you want to start?
The 3 levels of the Kansas state court system really is that there is the trial court, which can consist of district magistrate judges and district judges. We have one of your former chief judge here in Salina, Judge Hebert, here with us tonight. They hear the trials that you're used to hearing, where the witnesses are sworn in, they give testimony on the stand. All of that is transcribed by a court reporter. The jury or the judge reaches a verdict, makes findings, makes rulings. And then, once that is over, the parties would have a right to appeal that judge's decision, and depending upon the nature of the case and the issues, that appeal would either go to the Court of Appeals, which is an intermediate court that hears many cases. They usually set in groups of 3 at a time to hear panels of a large volume of cases, and the judge is now doing that as a senior judge and hearing some of those appeals. Other types of cases may come to the court, to the Supreme Court directly. Some will go to the Court of Appeals first and then to the Supreme Court, and I'll let Carol explain kind of how those take those different paths.
Yeah, there are essentially 3 ways to get to our court. One is the one that Marla just mentioned, and that's cases that go first to the Court of Appeals, and then the party that's unhappy with the outcome has an opportunity to file what's known as a petition for review by our court. We get anywhere from 750 to 900 petitions for review every year that we review, as the name implies, to decide whether the cases merit review by our court. So that's one method to get to our court. Another method to get to our court is known as an original action. And the original actions come directly to our court. They're filed in our court in the first instance. That's why we call them original actions. They can often be kind of, I say, hair on fire cases. If I say that, you know what I mean. People are in a hurry and they need a quick resolution. So, for example, a recent case that fit that mold was the Wichita marijuana ordinance case. And that action was brought originally in our court and resolved pretty expeditiously as a result. And certain types of actions can come to us that way. And the third way to get to our court is automatic direct appeal to our court. As Marla mentioned, there are certain types of cases that come automatically straight to the Kansas Supreme Court from the trial court. So, for example, in the criminal realm, all cases of first-degree murder come to our court straight away. They don't go through the Court of Appeals. In the civil realm, the statutes provide, for example, that eminent domain cases come directly to our court, those cases where land's condemned for a public purpose. So there are just certain types of cases that come directly to us. So you have those 3 methods. They get to us on discretionary review, petition for review. They come to us in original actions, or they come to us on direct appeal that's automatic to our court. I like to say that many of our cases choose us. We don't choose them. And that's true of all of them outside that petition for review area. And even with petitions for review, we have guidelines for what we should take when there are conflicting decisions in the Court of Appeals, for example, or an issue of particular public note, something that needs to move the Kansas law forward. So we really don't have ultimate discretion in those as well. We have guidelines that help us make a decision on whether to grant review.
So on those discretionary cases, let's say the Court of Appeals is divided, strongly divided, and then you have to look at how does that work?
We have to decide.
You just have to decide.
We have to decide if one or the other side is correct, or maybe there's some middle ground that works. I think we have a case on this week's docket where we have directly contrary Court of Appeals decisions. The panel, as Marla mentioned, the Court of Appeals sits in panels of 3. There are 14 judges on our Court of Appeals, but they decide cases in panels of 3. And they are not bound by one another. And they're rotating panels. They're not set panels. So that makes for some lively discussion at the Court of Appeals level that sometimes we have to settle.
So how many cases do you end up handling in a year?
Well, in addition to the 700 to 800 petitions for review that we review every year, we also handle another 200 to 250 cases a year that reach a written decision by our court in some form. And in addition to those, there will be these original actions. And the number of those can vary dramatically year to year, but usually somewhere around 50 to 75.
It's pretty busy.
You,
I would say.
I tell people if you don't like to read, don't seek this job.
So how does it work when you approve or you accept a case? What happens?
What are the steps? Kind of what are the steps?
Yes.
The first step is that the parties' lawyers file written briefs, and that's kind of a misnomer. There's a 50-page limit, generally speaking. They're not especially brief. Most lawyers, I know this will shock you, like to use every page. So anyway,
with narrow margins.
narrow margin.
They're writing
narrow
real
margin.
small.
The advent of word processing that wasn't selectric typewriters was really a bane to the existence of judges, I think, because there were all kinds of tricks you could play with typefaces and stuff. But at any rate, we get briefs, and then the next step is to hear oral argument. So, for example, this week we're hearing a week of oral arguments up in Topeka, which you can watch on live streaming on the KS Court's website. So we hear oral argument. Prior to the time that we hear oral argument, one of us has received a tentative writing assignment on a case. And we have research attorneys who assist us in not only reviewing the briefs, but reviewing everything that went on in the district court, the record of the case. And they help us to do research and prepare for oral argument, write us a memo that's published to the whole court. So after oral argument, we go directly into our conference room, and we, as my dad used to say, cuss and discuss. We resolve the case. We discuss it. We discuss the merits of the various issues, and we vote. And we decide whether the person who had the tentative writing assignment is still in the majority, and if they are, that person keeps the writing assignment for the case. And then we go back to our chambers after oral arguments and conferences are complete, and we draft the opinions. And I'll let Marla take it from there.
The opinion drafting is usually based upon the discussion we had in conference. If I'm the judge assigned to write it, my goal is to reflect what the discussion was by the majority in that case. We may leave that conference room without being unanimous, so that we know going forward that there are going to be several separate opinions taking different viewpoints. So that the principal or the majority opinion will be written, and then that will be shared with any of the justices who plan to write separate opinions, which may agree in the result of the majority. We call those concurring opinions. It's just that they will disagree with the rationale or the analysis of how you get to that result. But then there may also be some who just disagree with the result, and so those will be dissenting opinions. Once all of those opinions are written, then all of that is shared with the entire court, and we like to grade each other's papers. We may have marks on them that are as simple as a comma here or there, or it may be paragraphs of substantive comment about why we think this needs to be reworked, or problems that we see with the analysis. And so there's a lot of vetting and going back and forth and continued discussion until we are comfortable with the opinion as a whole.
So your debating proved to be good training in the conference room where you have to argue about everything. How does that work? How do you maintain how does that work getting along? And are there how do you do that?
I think that our training as attorneys helps us with that, because we are used to being adversaries in the courtroom, but being able to walk out of a courtroom and be friends. And it's just a high level of professionalism, I think, that allows you to have strong discussions, but understand that you're disagreeing about ideas, not necessarily taking them as a personal attack on you because you disagree. And we really have. I feel fortunate to have worked with the group that I do, because it is a very collegial group, so that we're able to have those robust and open discussions. I don't think anyone feels that they have to hold back, that idea sharing can really occur in a way that hopefully lends itself to making a stronger decision by the court.
It's very mind expanding, really. I always think that about oral argument. There are some judges who say they don't find much value in it, and I've always found a great deal of value in having the lawyers come and visit with us and give us an opportunity to tell them through our questions and exchange what's bothering us about their position. And it's the same way in conference. I always learn something from my colleagues, even if I'm well prepared and ready to go. There's always something that I learn from visiting with my colleagues about the case.
And everything goes right back to the Kansas Constitution, is that right? Is that what drives your, guides your conversations and the way you deliberate?
Our oath is to uphold the Constitution of the state of Kansas and this Constitution of the United States, and that is the pole star of everything we do. The rule of law, of course, is the other guiding factor in that we know that under the rule of law, the law applies equally to everyone. It does not matter what your position is, what your background is. We are all under the same rule of law. And we also understand that there are certain principles that we are to follow. Some of them are that if the legislature has spoken on a statute, we do not second guess the policy of the statute. Our job is to enforce that law. One of the things we do quite frequently is sometimes try to figure out what the statute means. And no offense to the legislature, they try to make them as clear as they can, I'm sure. But when it's like with many other written documents, when you put them into practice and you actually apply real facts to them, you see nuances and things that's like, well, that just doesn't quite fit. So now what do we do? And so we're faced with, our job is to interpret how to apply the written word to all of those little nuanced ins and outs. And there our guiding force is that the intent of the legislature controls. And so that's what we try to determine. And then I guess the other overriding factor is the rule of precedent, which is that if the court before us has made a decision in an area and established a rule of law, we follow that rule of law unless we are convinced that it is so wrong it's causing more problems than would be aided by us following it. And it's not something that we change lightly, that we change course, because the entire system is built on the stability and predictability of that rule of law. The judges sitting in the Salina courtrooms need to know what our court has said and that we will continue to consistently apply that in future cases. So those are the principles that primarily that guide us. There are many others, but those are the ones that almost always come into our discussion every day.
As the third branch.
As the third branch. Yes.
Right. So how long does it take to settle a case? To get your
arrive at a
opinion
decision?
and arrive at your decision?
It varies from case to case. Some of them are one issue, simpler. Some of them take a huge amount of resources. I'm sure you can imagine that the complexity varies. And so that really kind of governs how long it takes. Mm-hmm. And the other thing that makes a big difference is that process that we were describing a moment ago. If there are separate opinions, if opinions change after conference, sometimes it takes writing a decision to really solidify your view, or reading a colleague's decision to make up your mind. And so that can really lengthen things as well. But I think complexity of the case and the necessity for separate opinions are the things that really drive that a lot of the time.
Sometimes someone will be incredibly persuasive on paper when they didn't seem to be so persuasive in the conference room. And so you read that, and it's like your tentative vote that we took in the conference room, like, well, I'm going to reconsider that, and you do additional research of your own, of course. And sometimes that will cause, we call it flipping the case, so that the majority may become a different majority than left the conference room. And so those cases often take more time. And then we also often have the phenomena that someone will write a separate opinion, and the person who wrote the majority opinion will go, my opinion would be stronger if I said those same things. And so It's sometimes frustrating if you're the one that spent all that time writing that separate opinion, but it will get merged into that majority opinion, and you just go throw your draft into the recycling bin. So, but obviously,
painful.
it
You
is
have
painful.
to kill your children
It is
sometimes.
painful.
As they say.
You know about that.
But obviously, anytime
Writers.
any of those things happen, it makes it a longer process.
Right, yeah. So, knowing that you can't get into specifics, what are the categories of cases that challenge you the most, that you find the most, that appeal to your wanting to serve the public? That, just what are the variances of the cases that you take, and how are they challenging in different ways?
I think one of the principal challenges of our position is that we really, as Marla said, have one central duty, and that's to honor our oath. And that often requires us to set aside our personal feelings on very compelling matters, because we're human and we have families and relationships like all of you. And so we react in human ways to those compelling circumstances. And we have many cases that require us to keep in mind, principle that oath, and our primary duty to always be fair and impartial to both sides, no matter whether they're admirable or not. And that can be hard. That can be difficult, because we're really not permitted by our oath to consider our personal druthers in any given case. We often say that there's no docket that goes by where we don't have to vote in ways we would prefer not to have to vote, because our responsibility is to that rule of law and not to our own preferences. So that's one of the most challenging things, I think.
We see a great deal of human tragedy in our courtroom, as do all other judges. And sometimes there are decisions that are made that will cause harder situations for individuals. But it's what is demanded by the law. There's not a way necessarily for us, we cannot rewrite the law to make it easier for all parties. We have to enforce the law as it's given to us. And we're not, as I mentioned, we don't reevaluate the policy. We can't sit and say, we think this is really a stupid law. If I was across the street in the legislature, I would not vote for this statute or this law. But it's what I have, and it's what I have to do. And sometimes that can just tear at your heart because you understand the ramifications for individuals.
What sorts of other responsibilities does the court have, or do you as justices have?
The court also sets as basically the board of directors for the judicial branch of the state of Kansas, which means that we administer the budget, we supervise the employees across the state, and do many other tasks. Of course, we're aided in that by the chief judges who are in their local areas. And so the way we do that is that the state is divided into 6 geographic departments. And the chief justice, of course, is dealing with many, many of these issues at a higher, on an everyday level. And then the other 6 of us will take a department and be responsible for the courts that are within that area. So sometimes we're dealing with human resources issues. Sometimes we're helping deal with coverage for if they have a judge with an illness, or if they just have such a high caseload that the judges aren't able to cover. We're helping to try to manage some of those things with them. In addition, the Supreme Court has many boards, commissions, and committees that help us with our various tasks. And each of us then serves as liaisons to several of those groups, which can range from meeting with that group on a regular basis to sometimes being very hands-on in helping with that particular area. For example, I am the liaison to the Commission for Judicial Qualifications that deals with the discipline of any judges in the state who might violate our code of ethics. I also chair the Judicial Council, which is a group of legislators, attorneys, and judges who make reports to the legislature on various issues that, with the goal of improving the judicial system and laws. Just as a couple of examples.
Yeah,
Carol has some.
we all have liaison responsibilities, and as Marla said, those departmental justice responsibilities. We have a colleague on the Court of Appeals, Steve Lieben, and he refers to all of these responsibilities that we've just described as the invisible work of the court. And it is kind of invisible because the work that all of you see or might be exposed to through press reports, for example, tends to be our decisions in cases. But all of this work is kind of going on behind the scenes. And it can be extremely time-consuming, especially in the kind of lean budget years we've been having, several years running now. It takes a fair amount of juggling and discussion on how to manage scarce resources, as you can imagine.
So what are your favorite parts of the job, and what is the most challenging?
The favorite part of the job is that mind-opening experience that Justice Beier referred to. There are times that we will be involved in a very robust discussion, and I just kind of sit back and think, and the people of Kansas are paying me to do this. This is amazing. So the intellectual challenge that causes you to grow constantly. There are the diversity of our job. There are no two cases that are alike. And so we are learning every day as we go through the process about with attorneys who present us new arguments and new things. So it's a job that continues to challenge us in many of those ways.
Even as we were driving out here, we were talking about the odd little facts we accumulate knowledge of because we have a case concerning an area that we've never been exposed to before. And that happened when we were practicing, and it certainly continues to happen. So that learning is really fun. I get a big charge out of oral argument. I really like that exchange with lawyers about their case. I love school. I love school all the time. And it's a little like that. I mean, it really is that vibrant digging in and unpacking the argument that I just really, really enjoy. And it's fun to do with the lawyers. They're the ones who are teaching us, really, in that scenario. And I always say that to lawyers when they want advice about how to conduct their argument. I tell them, I know it's difficult when you have certain things you want to say that you think are most important. But really, the most important things you have to say are the answers to the questions we have. So try to greet our questions with a smile on your face. Sometimes they have a hard time doing that, but I really enjoy that part of the job.
Mm-hmm. Maybe give you a little bit of an idea. This morning we heard 5 cases. The first case was about some ins and outs of the act that deals with sexually violent predators. The second case arose out of a civil case, a car accident, although it primarily dealt with attorney fee issues that related to that. The third case was a post-conviction criminal issue where a defendant was arguing about whether or not he had ineffective assistance of counsel. And then we also had a judicial qualifications, a judicial discipline case. So that's kind of a typical day. It's a really diverse kinds of topics that we're touching on almost every day.
What's challenging? Like, what issues challenge either your lifestyle as a judge, your, how does the public keep up with what you're doing? Because you do a lot of your work just in those chambers behind closed doors?
I would say that is another one of the chief challenges of our job, I think, is making sure that the public does understand what we do. When I took the bench, and Marla, you may have had some of the same experience, but I think it's especially acute at the appellate level that, because the district court, you're seeing more citizens every day. They're in and out of your courtroom. And we're definitely more of a cloistered life. We see lawyers. We don't hear witnesses. We don't pick juries at the appellate level. We have lawyers come and make arguments. And so one of the challenges is not being isolated and being in touch and making sure that people understand what you do. And I think we've been doing a really good job of that the last few years. Starting in 2011, the court went on the road for the first time. We went all the way across the street to the historic Supreme Courtroom in the Capitol building, and we held a session of court, and that went okay. So after that, I think we've now visited 10 other communities to have court proceedings in those communities. We were here in Salina. I think that was one of our first outings, wasn't it, Dan? I'm pretty sure. And we've been in several other communities, large and small. We're going to do our 12th outing of that type in Hutchinson in October. And we've also learned, as we go, the best way to reach more people and have them have the opportunity to observe our live proceedings. So we started having night court. And we've drawn hundreds of people in communities like Hayes and Hiawatha. And it's been very rewarding. But I think that is a challenge of the job. We have been working really hard at more transparency and more public exposure so people can understand what we do.
You've all seen TV shows about trials. It may not be very realistic, but at least it gives you a concept of what it's like to have what a trial courtroom is like. I can't imagine a reality show of appellate jurists. So, it's just not something that, in the popular culture you get exposed to in any way. So it really becomes our challenge to kind of help you to do that. And we laugh that there's one photo of me that kind of continues to reappear in all the papers. And I'm going like this. And it's like, well, of course that's the one they pick. It's an action photo for us.
Lifting our pen, an action photo.
So.
Okay, this is a sort of a. There have been. You've been in the news a lot lately. There have been more than 50 pieces of legislation in the last few years about judicial selection, tying the judiciary budget to case outcome, impeachment, etc. This retention campaign or retention
election.
Yeah. It's not really. Anyway, talk about that. What can you tell us about that? How?
What's going on?
What is going on?
Marla, you want to go first?
The challenge for us is that as things happen, we have had situations where we feel that because of discontent with situations that our employees even are not getting the fair treatment that they should in the budget process. Mm-hmm. Our judges have not received a raise since 2008. Our employees have had one raise that was then more than eaten up by health care and CAPERS or their retirement system increase costs. And so we have felt certainly that there is pressure. And the important thing for us is that we have to always remember that our oath, as we said, is to uphold the Constitution. And that Thomas Jefferson said, the most sacred thing that a government can do is to bring fair and impartial justice. And that's our role, regardless of what the outside pressures might be. And so anything that, regardless of what is happening in those situations, our job remains the same, and we have to rise to remember that and make sure that we are continuing to work towards being that fair and impartial court that we need to be, regardless of those circumstances.
It's been an interesting environment. You know, the old curse about living in interesting times. I think we've been living in some interesting times lately. You know, it really comes down to pretty basic civics. And the fact that we were designed very intentionally and very thoughtfully to have two representative political branches of our government, and one that was neither representative nor political. And whether we want to maintain that design, that's what it really kind of comes down to now. That has been under pressure. It's only natural that when you have a system like that, that's designed to have checks and balances among the branches, that tensions will arise. And some normal level of tension is to be expected. But I think we've obviously seen increases in that tension of late. And it does make it challenging. But as Marla said, really at the end of the day, it doesn't alter our responsibility and our duty to deliver fair and impartial adjudication of disputes. And when those disputes arrive, we have a duty to decide them. Period. We don't have the option of avoiding, putting off, delaying, waiting for the next session. The decision arrives, and we must go forward. That's our duty. And that sometimes causes us to be somewhat unpopular. But again, it goes back to where I started, to those two branches that are representative of the majority and of the political will of that majority, and a branch that is designed to be independent of those pressures. We just have to remember that and soldier on.
So you mentioned the being appointed, and then you go through the retention. So have you both sat through retention campaigns? And this year, I mean, nationally, all eyes are upon this Kansas situation. Just talk about that a little bit. What was it like before? What's it? I mean, in as much as you can, it seems particularly fraught this year. And
I'll go ahead and start if you want, Marla, if that's okay. This is not completely new to me. I had a little bit of a challenge in 2010 as well. Marla sat at least twice. Well, you sat several times in the district court.
This will be my sixth retention.
Sixth one. And this is my fourth. Marla was on the district bench for several years before I came to the Court of Appeals, so she's had more chances to do this. Yeah, it's definitely more intense this year. And again, I think there are those who would like to see a situation where the judiciary was a little more captive to majority will, perhaps, in certain cases, but I think special interests in other cases. And so we're attempting to resist that. But honestly, again, retention elections are different from ordinary elections. And judges, as people who appear on the ballot, are different from ordinary political candidates. Our conduct is governed by a code of ethics that prevents us from discussing, for example, individual cases, even steers us away from discussing more broadly certain issues that are likely to come before the court. So we are really not in a position to speak very much about issues that might come before the court, and that prevents us from any kind of campaigning in the traditional sense. We speak, by and large, through the decisions we write, and are limited to that. So it's an interesting...
As a body, as a full...
Yeah, it's a body of work. It's a body of work, and we're best understood really that way. But we have to rely on other people to speak for us and speak for whether they want to maintain a system like we have.
Our jobs are very different than those that are in the political branches of the government. Judge, did you ever get to pick a case that came to your courtroom? No. Somebody else sets our agenda. We're not like a legislator who can say, I think that's a great issue, but this really isn't the year to bring that question up. We don't have that luxury. It's in our courtrooms. We have to decide it. And we don't take a poll to say, what would the majority of Kansans think about this situation? We are not there in that capacity. But that said, we do represent the people. And in fact, we represent you in the way that we are enforcing your supreme voice. And that is that a supermajority of Kansans have adopted a constitution. And our job is to enforce your voice through that constitution. And if the legislature chooses to enact a law that's contrary to that constitution, even if the whim of today's majority might be different than the majority that have stated in that constitution is what controls. And so, of course, that does cause friction, and it causes problems. And as I said before, we are trying to, and our goal is to enforce the legislation and the intent of the legislature whenever we can. And we do sometimes miss the call. And they will say, that's not what we meant at all. They do have the ability and the checks and balances to counter that. They can pass new legislation and basically overrule us. And that's the way this system was designed to function, is in that way. At the national level, many of the amendments to the United States Constitution have resulted from a desire to overturn a court case of some sort. And so that's the way this checks and balance system works in terms of checking what our decisions might be if if a majority of the people do disagree. But the result of all of that overall, as I said, is with our goal to enforce your voice and to always do it in a manner that is fair and impartial, so that it's been described as the courts being the great levelers. My favorite passage of describing that is Harper Lee's writing of Atticus Finch's closing argument, where he tells the jury that it does not matter if you are a pauper or a Rockefeller, if you are an ignorant man or a college president, if you are an Einstein, or I won't use the word he uses as the opposite, regardless of where you stand in that status, you walk into a courtroom and the courtroom is the great leveler, and you will be treated equally in that courtroom.
Thank you for your public service. First of all, I have to just say that right now after that lovely speech. And I think we have some questions from the audience, which we'll launch into here. Thank you for your questions. First of all, there are a lot about campaigning or addressing certain issues in certain communities maybe that you've ruled on. What are the parameters of what you can and cannot do in those situations? One is, can you go to, has there been a concerted effort by the justices to go to communities to address certain issues during an election?
We cannot speak about any decision we've reached, any case that might be coming before us, or any case that might in the future come before us. So what our goal is to educate people about how the court system works, what we do consider as we make those decisions, and try to help people understand kind of this behind-the-scenes function so that they do understand the importance of fair and impartial courts and how those can be maintained.
And what about campaigning? Are you allowed to? It's so tricky.
It's just not anything that anyone would in today's age would recognize as something they call a campaign, partly because of what Marla just said, kind of what I referenced earlier. There's so much that we can't really discuss. So, for example, as judges, we are prevented from saying, well, I have this opinion on this issue, and I will rule consistently with that. In the same way that, for example, if I were running for a legislative seat or an executive branch seat, I would say, well, my position on this issue is X, and you can count on me to try to pursue legislation that will accomplish X. We absolutely do not do that, and it would be completely inappropriate for us to do that. And in fact, to the extent people tell you that's an appropriate thing for a judge to do, I want you to be critical thinkers, because I think that's a cynical view, and one that does not appreciate all we've been discussing this evening about how judges do their job. So it doesn't really resemble the ordinary campaign. We are prevented, for example, from endorsing one another. So, even though I think Marla's the best thing since sliced bread, I can't tell you to retain her. And she can't say that about me. We're prevented from doing that by the canons of judicial ethics. So it is a very kind of unusual circumstance, and kind of circles back to what I said earlier, that we need advocates among the public who are educated about the system and who can be both proactive in talking to your friends and family and neighbors about these issues, but also reactive. So if you hear someone make a misstatement or something perhaps less informed than you all are after tonight, speak up. Stand up. These basic concepts we've been discussing tonight are not new. They're old, and they're by design. Ever since the Declaration of Independence attacked King George for courts that were not fair and impartial, we have wanted courts that were the great levelers in our country and in our state. That's been our standard. But if you want to protect them, the new thing is that you're going to have to stand up and say so.
I think I know the answer to this next one, but I do want to put it out there because I think there's so many layers. Does the threat of the loss of your retention affect your performance, and has a retention vote ever affected the court? I mean, I know how I would answer that. I think you're trying to be more transparent. I don't know that. I think you've probably always done your job well and been committed to it. So I'm speaking my opinion, but can you reflect on that too?
I think that's accurate. I mean, again, there are things we probably could do in our decision-making that would help us in a retention vote, that might make us more popular. But that's not the way we vote. We have to look at the issues and the facts that are presented to us and sometimes make that decision that we know is going to raise some eyebrows. But it is what the facts of the case as presented to us, the issues as presented to us, the law as presented to us require us to do under those constraints that I mentioned earlier that guide our decision-making. And so that is our principle. That's just all we can do. We cannot act in a manner that helps prepare us for the outcome of that election.
Enhances our chances. I was speaking at Pittsburgh State recently to some college students. It's always lots of fun, and they were really well prepared by their professor, and they had all kinds of really terrific questions, and I enjoyed it a lot. And there was also a political science professor who was in the room, and he said to me, okay, so you say that when you make your decisions as a judge, you consider these things and you do not consider these things, like your personal views or whatever, your personal preferences. How do we know? That was his question. It was kind of a challenging question. He said, how do we know that's what you're doing? And I told him, I said, well, I guess when my vote happens to coincide with whatever those poll results would be that we don't take, that poll we don't take, but whenever my views happen to coincide with those, maybe you don't know. But I can tell you, what am I doing if not following the law when it's very obvious that my vote does not conform, or that non-conforming vote comes at a very inconvenient time? What else would I be doing other than exactly what I'm supposed to be doing, which is following my oath and following the law?
So restorative justice is also an important concern in Salina. What thoughts do you have about restorative justice, and how it could change the court system in our state?
I can answer that in terms of my involvement as a chief judge in Shawnee County as one of the first courts in the state to implement a drug court. We really were early in that process and dealt with a lot of issues that had to be taken to the Supreme Court to give us the authority to even establish a drug court and to do that type of thing. And as that has grown, there are now several drug courts in various parts of the state. In Johnson County, we now have a veterans court, and we also have some courts who are doing mental illness courts. And all of those are designed around the philosophy of restorative justice, which is, in the broadest of terms, if I can describe it, rather than the typical bringing people into the courtroom and doing nothing more than sentencing them and sending them on their way, almost from the first steps into that courtroom and the early part of the process is usually, we are bringing them in with a team of people who can help them with resources in the community, whether they be financial resources, mental health resources, and other things, to help them deal with whatever the systemic issues are that are leading to their criminal behaviors or patterns or other things that are bringing them into the court system, their inability to care for their children, the variety of types of cases that we do see. There are two major constraints on the growth of that system: resources in terms of budget, time of the judges. Those courts take a tremendous amount of not only judicial time, but of the team, the court services officers, and the others that are involved in it. And then the second one is the community. The community really has to be behind this effort because it draws from resources all over the community, not just from the judicial system. And as a result of that, we do not really have resources within the state budget to help. We're just trying to keep our basic services moving without adding other things. And so the growth of this has been something that as a court we have just tried to open the doors and to encourage local areas to examine what their community needs are and how best to carve a restorative justice system in their local community. And the various courts around the state are being very innovative, coming up with many wonderful ideas. And so far, the successes that we're seeing are just jaw-dropping. They are amazing. And so we're very encouraged and hope that the system will grow and that the resources will grow in turn so that we can help more and more people in that process.
I think that one of these won't be, I don't think you can answer it, but I'm just going to pose it. What would happen if one or more justices are not retained after they have held hearings in Gannon but have not yet rendered a case or a decision?
We can address individual cases, but I'm at least recused in that case. So let me just talk generally. I don't think we necessarily know the answer about any case that has been heard that has not, a decision hasn't been rendered. We have personnel changes on the court for other reasons, not on a regular basis, but periodically. And sometimes a judge will be substituted for, that sort of thing, ultimately. Maybe from our stable of very able senior judges. They'll come and help us out. But we haven't had a situation before where there's been a change because of a retention race. So I guess it would be a new frontier, one we hope we don't see. But
perhaps the one clear thing is that a judge's authority ends at the end of the term. Mm-hmm. And so the judge would not be able to do anything related to anything that might still be pending as of that last day, the day after that last day of term.
Okay. I think these two are somewhat related. There's one is, what is the greatest fear of the current judges not being retained? What is Brownback after, and why? And then the next one is, if you are ruling just by the Constitution, why does it matter which? What does it matter who appoints? Mm-hmm. They're kind of related a little bit. Yeah. I mean, one is personal and one is general, but
let me address the first part, if I can. The fear. First of all, I really don't think this is about individuals. And it goes back to what I was talking about a few minutes ago. I think it's about a system and about understanding how the system operates and not being cynical. Not being cynical about what the job entails and have that drive who should be in the job. So I don't think it's really about individuals. You had 3 questions there. Remind me of the third one.
Well, there's one, what is Brownback after?
I don't think I want to address that. I don't think either of us can read minds. So
right. And if you are ruling by the Constitution, why does it matter which political party or governor appoints?
I don't think it does. Marla mentioned that she was originally appointed to the district court by Joan Finney and then appointed by Governor Graves to the Supreme Court. I was originally appointed to the Court of Appeals by Governor Graves and then appointed to the Supreme Court by Kathleen Sebelius. I can tell you one thing that never comes up in conference on cases, and that's what party we belong to. Not once, ever, in 16 years, in my experience. And I can tell you, as I sit here, I'm really not certain the party of each of my colleagues. That's how little it matters to all of us.
The idea with all of this is that it is nonpartisan. And I think that the threat of what could happen here is that there would develop a system where people thought that the retention could just be a way to affect changes in the law that they might not be able to get through the legislature. I mean, I think there's some sense of that, at least by some factions. And I think if those of you who are students of history would look back at various court, as they're known, court packing plans that some of our United States presidents have had, or some of the times that they have made appointments with specific issues in mind, and then that history will tell you it doesn't work that way. I think that President Truman said that one of his biggest disappointments in his office was with his Supreme Court appointees because they didn't vote the way he wanted them to vote. It just is, again, the people who are in that position take it seriously, I think, and so that doesn't mean that they look back to what it was the person who appointed them wants them to do necessarily. The concern is, I mentioned to you that we we follow precedent. We look back. I just was writing something last week where I was citing cases that are centuries old from England. Centuries old. I mean, we look back that far on occasion because we need the stability of that law. And we want to continue to have that. The idea is not that every few years we're going to be changing a lot of rules and changing the way we do things. That would be counter to the rule of law as we have all known it, as our founders of our country envisioned its application in our system of government.
How many hours do you work in a typical day or week? And what do you bring to the court as women?
I think that the worst challenge on a personal level of our job is trying to find a way to find any kind of personal balance in our lives. My sister is in the audience. She can maybe tell you how many holidays I sit with a stack of work at beside my chair, ready to grab at any downtime or whatever. I'm not that bad, but it's close. It really is it can be a very consuming 7-day-a-week job if you allow it to be, and at times we have to make it be that to just get the stuff done. So that definitely is a part of the negative of the job, I guess. So.
And then what as women do you bring to the court that's different from men, or that you feel like?
Well, I think we started this discussion talking about diverse backgrounds. And I think it's obvious, as women of a certain level of maturity, shall I say, with a certain background, kind of Marla and I, even though we came from opposite ends of the state, are of the same era, and have some shared experiences as women, as wives and mothers and neighbors and PTA members. And those experiences may differ, in part because of the generation we're from our male peers. And I just think that every experience that all the members of the court brings that differs from their peers is valuable. Again, partly the reason why we go into conference and we have those moments where we think, gee, I never thought of it that way. Because all of those experiences build the people that we are and the diversity we bring to that table. And I think that's the strength of an appellate court, of a 7-person court, is that you have those diverse experiences.
I mentioned that one of the motivating factors for me to even seek that first judicial position was diversity. I think that, and it is critical that our bench reflect our communities. People on the other side look back at what does the bench look like, and it needs to look like our community in order for them to trust it, to value it, and to understand it, I think. So I hope that we can all continue to work for broader diversity in all levels of our system.
How do you define adequate and equitable as applied to education financing?
That one we can't talk about. We just can't talk about it. We have a pending case. And although I'm recused from the current case, I have sat on past cases and will sit on future cases probably if I'm permitted to do so in November. So we really can't talk about the school finance case.
We've mentioned a couple of times that all we can say is in our written opinions. Hopefully you picked up those sheets about being an informed voter on there. You will find on there the kscourts.org website address. On that page, you will find all of our published decisions. And you will also find many archived arguments at least for many years back. I'm not sure exactly when they start, but for I think over 10 years, audio of oral arguments, and for about 6 years now, maybe, video of those arguments. I know some of you have probably read the school finance decisions, but if you have questions about how we have answered those and defined those terms, you can find those in the Gannon or the Montoy decisions. And that's a place where you can go to find those opinions and to read the written explanation of how we would define those terms.
Or any other issue that interests you.
Okay, I'm going to ask two real quick, three. Do you all review the 700 to 900 cases to decide?
The pattern when we joined the Supreme Court bench, every justice reviewed every single one. And we now have instituted, because the number keeps growing, I think the average of, I don't know what the year's average was, Marla, was in the 750 range.
750 is the range.
But last year we had 900. So these are just growing, not quite exponentially, but quickly. And so we've had to institute some measures of triage, basically, where they get put into categories of cases that require all 7 of us to decide whether the petition should be granted, those that can be decided by a summary panel, and those that can be decided even by an individual justice with the assent of others. So we have instituted measures to try to keep control of those numbers that are growing and try to keep them moving so that people are getting an expeditious answer on whether their review is going to be granted.
Okay, if the state of Kansas, under the governor's leadership, delays, defaults, or otherwise fails to contribute its agreed payment to the Capers Fund, how is that not a breach of contract? I don't know that you guys can...
We are actually prevented from giving legal advice, so we can't give you any legal advice. What I would say is kind of reminding you of a recurring theme here, and that is that we must decide those cases that come to us. But we don't start them. Other people start them. So, for example, if there's a law that someone feels is unwise or unconstitutional, we don't act spontaneously. Someone has to bring that challenge to us. And that would be true of anything like that, any kind of contest over that sort of an issue or many other issues.
Okay, and the last question I want to ask is, what are your feelings about, and this is phrased as activist judges or justices, isn't that something that's applied to a justice or judge from the outside? And it seems like a contradiction in even doing your job.
There's kind of a joke that an activist judge is the one who ruled against you. And it's a joke, but it's kind of true. It tends to be a term that gets bandied about when someone's disappointed in a ruling. It really actually has some substantive meaning to lawyers, and it has to do with departing from what we've been talking about, from the rule of law, and engaging in the kind of behavior that the cynics would have us believe judges engage in all the time. And I'm reminded of a piece I just read recently. It had to do with several recent fiction and nonfiction works about the Underground Railroad and about our desire, kind of our collective desire as a society to believe in the nobility in people of that era who participated in the railroad. And it said that we shouldn't deceive ourselves that the times were somehow extraordinary, that we should recognize that a desire for better is within, not without. And this reminds me of that. This is your system. This is your system, and it's going to be up to you to protect it and to recognize that that activism is more of just a casual insult than a substantive concern in Kansas.
Okay.
Thank you all.
Thank you.
One last note to those who are in the viewing audience who may see this at some time during the election season up to November 8th. You can see the degree of study that has gone into fairness and impartiality in the interests of all citizens. So, citizens who are out there, your responsibility is to study as deeply and responsibly and vote in the same way. Thank you very much, Justices and Sarah Bagby, for appearing here.